Good morning, everybody, and welcome from the Senior Law Day Collaborative. Sarah Steckler. I'm one of the three co-chairs for Senior Law Day with Elena Falcone, who's the Director of Public Engagement for the Westchester County Library System, and Melinda Bellis, who's the Attorney in Charge for Legal Services of the Hudson Valley. Today, we have a terrific program for you with a very exciting speaker, so I'm going to give a warm welcome to Joseph Accetta, who's the court attorney referee for Supreme Court for the Westchester County Guardianship part. And he also has spent time as the chief clerk for the Surrogates Court. So he has a very wide depth of knowledge in both areas of the law. So we're very excited to have him here with us this morning. Before we get started on our program, I encourage everyone to visit us online at www.seniorlawday.info, where we have videos of all of our prior programs, our publication, the Elder Law Q&A, which contains helpful information on all information for elder law from A to Z, as well as our Ask Us button. So if your question does not get answered on today's program, you can go onto our website and click on the Ask Us button and fill out the query with your email address, and a professional will get back to you within 24 hours to answer your question. So without further introduction, please welcome Mr. Accetta this morning.
Thank you, Sarah. Good morning, everybody. It's great to be with you this morning. I would much prefer to be live a few feet from my office here over at the county center, but I'm very happy to have everybody here virtually on this webinar. I'm here today to speak to you about a program that I've done frequently with a lot of our seniors, and it's always very well attended. I always enjoy the give and take of the questions that we get, but this is really about whether you should prepare your assets so as to avoid probate, avoid going to the surrogates court when you die, and you're leaving your assets in the hands of the people that you've chosen to perhaps administer those assets. So you hear a lot of different things. Just quickly, background-wise, Sarah introduced you. I've spent the last 5 years of my career in the adult guardianship part, where it's sort of a precursor to what happens in the surrogates court once you do die. But I spent 20 years in the surrogates court, mostly as a court attorney referee, in the last 4 years as the chief clerk of the court in an administrative capacity, in which I stayed involved in the law. I still teach the law at our local law school here at Pace University in White Plains, and I teach paralegals at Westchester Community College in estate practice in the surrogates court. So I'm still well versed in what goes on, and I'm happy to share my thoughts and concerns with you and encourage your questions. So the principal tug of war here in this context is you're always told, surrogates court is a disaster, and it will take forever to administer your assets. You want to try to do everything that you can to avoid going to the surrogates court, to avoid probate. Probate is the process by which a will, which you have executed during your lifetime, is presented to that court for admission, and a declaration from the surrogate judge that the will is indeed valid. And that, of course, could produce a contest, and we'll talk about some of those parameters a little bit later. But for the most part, the proceedings in the surrogates court are not contested. It's because usually you've taken care to, A, keep your family members, your close family members especially, in the loop in terms of what your assets are, what your estate plan is. You've let the people know who need to know, who you've chosen to administer the assets, what you expect of them. And again, there's no question about it that this often causes angst. It often causes conflict among siblings who may feel that they've been overlooked, either monetarily or in terms of being charged of everything. And those are practical concerns that you have to consider when you're going through and planning your estate and planning for your demise. And that's okay. But to out and out say that, you have to avoid probate because the process is a disaster or it'll cost you a fortune and so forth is not necessarily true. And I'm going to try to dispel some of those thoughts for you. I'm not going to encourage you one way or the other, which is the better road to take, whether to avoid the surrogate's court altogether and put all of your assets in position before you die where they're going or passing to somebody either through some type of trust instrument or through some type of beneficiary arrangement where the assets pass to somebody you name by what we call operation of law, where you don't have to go to the surrogate's court to manage those assets because you've made arrangements for those assets to pass to somebody by virtue of a trust or an IRA or another qualified plan, or life insurance plans or TOD accounts. A lot of you are familiar with those terms. So let's take a few minutes to talk about the practicalities of those instruments. Now, in order to avoid having your estate pass through the surrogate's court, you have to ensure that all of your assets are not in your name alone at the time of your death. And the best way to go about that is to do planning, to get an estate attorney who you'll have a conversation with, and you will share what your assets are currently, what your plan is, how you'd like to dispose of the assets, and to whom, how much, and so forth. And the estate planning attorney will typically then assess your circumstances, not only for your own personal reasons, but for you to get the best tax benefits from the way you want to arrange your assets. And we'll come up with a plan. And that plan could involve numerous different types of vehicles by which you shield your assets or you put your assets in so that at the time of your death, the assets are earmarked to go to somebody without having to pass through the surrogate's court. The primary vehicle for that, and you're being told, well, you have to real property. Okay, there are trusts for people who have special needs. It's called Supplemental Needs Trust, which are not only planning tools, but also are tools which allow you to receive social assistance from the county in terms of Medicaid benefits. So those trusts are there to supplement Medicaid benefits for somebody who for whom you've set the trust up, who is under disability of some sort. There are living trusts, revocable trusts, and irrevocable trusts, and there's a lot of terminology that you get that gets thrown out at you. But the idea, again, behind estate planning trusts is really to have those trusts. With respect to those trusts, also, you have to complete a listing of the assets that are going to be put into the trust, which is called the Schedule A. And you got to be thorough about the inclusion of the assets that you want in the trust so that you are not involved ultimately in leaving assets in your own name, because those assets will then have to pass through whether you will when you have assets in your own name. And I'll explain that a little bit more about that in a little while. Okay, so the trusts, again, when you talk to an estate planner, okay, I am not an estate planner. I'm a member of the court. I've spent my entire career in the courts as a court attorney or referee or administrator. So I cannot give you legal advice, but an estate planner can. A good attorney who will size up your situation, what tax benefits are best for you, what plan works best for you in terms of keeping everybody as happy as possible. And just like anything else in life, it's very difficult to keep everybody happy when you're planning out your estate. You have to understand that going in, the estate planner isn't a miracle worker. Okay, the estate planner is not going to cure a lot of the family squabbles and so forth. You have to understand that. But the estate planner will be able to tell you, well, these are income, or you want to draw income while you're still alive from a significant principal, let's say real property, or a significant asset, liquid asset. Those issues, again, a good planner will tell you if a trust is beneficial to you, if you have the assets of significance, which make the trust a viable option if you want to ultimately draw income and derive the tax benefits that trusts typically have in doing your estate planning. So that's one thing that you have to consider. Okay, you also have pension plans, retirement plans, different qualified plans that are IRAs, KIOs, and so forth. And you get to constantly, as your life changes, as the people who come in and out of your life change, you want so that you know that you're going to survive, or the beneficiaries you've chosen are going to survive you. Because if the beneficiaries you've chosen do not survive you, then you wind up back in the surrogate's court, because for most plans, and goes for insurance or all of the other qualified plans that I've mentioned, the default beneficiary, when no beneficiary is either named or no benefits you, the default provision is your estate. And an estate representative would have to be appointed in order to get those assets and to administer them according to either a will, if you made a will, or if you didn't make a will. New York State has a distributive scheme, which it calls the Intestacy Statute under our state's powers and trust law. Specifically, it's section 4-1.1, which is a critical component of this process. So you have to understand that even though you didn't make a will, you don't necessarily avoid going to the surrogate's court if you don't do the other planning that we're talking about. So you can wind up before the surrogate's court as long as you die with assets in your own name, whether or not you made a will. You don't have to have made a will in order to wind up in the surrogate's court. That's called the process of administration, as opposed to the process of probate, which is proving the validity of the will that you've made. So those are all things that you need to be aware of in terms of how you want to set up your assets. If you absolutely do not want to be involved with the surrogate's court, then the best way for you to set up your assets is to take advantage of all of these planning vehicles, trusts, your various qualified plans. And again, a lot of this is going to involve your ability to draw income, to draw qualified lump sums at appropriate intervals as you age, with the remainder, of course, going to somebody whom you designate. Okay? Now, all that said, my goal here, or one of my goals, was to dispel the notion that you have to avoid the surrogate's court at all costs, because it's an endless treadmill of litigation, of wasting of time, wasting of money, and so forth. Now, I can tell you that it's certainly not cheap, your plan, to make the appropriate documents that you would need to execute in order for you to do your best to avoid the probate process. That cost can ring up to anywhere from low 4 figures into mid 5 figures, depending on how sophisticated your assets are. And that's something that you have to come to terms with, and you should probably shop around in terms of what attorneys are charging for that. The court does not get involved in that process. That's strictly between you and the people you choose to do your planning for you, provided, of course, that a court ultimately, if asked, determines that you had the faculties to do so at the time. Let's make that assumption at this point. But again, not all is lost if you ultimately have to go to the surrogate's court. Now, a lot of you have or go through the trouble of making a will. Okay, it's traditional. It's something that the common law recognizes as your last wishes, and the court, the surrogate's court, does everything it can to honor those wishes when a will is presented by the nominated executor, or somebody, if the nominated executor doesn't quite make it to the finish line or is disqualified for any number of reasons, somebody who's capable of offering the will to the court for probate brings it to the court. Okay, and that will operate on the assets that are in your name. Okay, the assets that you set up outside of probate via trust, qualified plans, life insurance, TOD accounts, those will pass to the named beneficiaries by operation of law. Those will not be part of the probate process, as I've mentioned before. But any asset that does remain in your name, whether it's real property, personal property, your belongings, okay, those are all property. Those are components of property that if you don't dispose of while you're alive, somebody will have to be appointed to dispose of for you. And it may be through a will or it may not be through a will. But in either event, those are things that you have to assess and you have to account for as you're making your plan. Okay, so let's assume that for some reason, some of your assets slipped through the cracks and remained in your name at the time of your death. What happens then? Let's take the two alternate scenarios that the court will typically have to look at. The first is whether you made a will. Okay, that will should be kept in a safe place, anywhere, by the way, but a safe deposit box. That is the absolute worst place you can keep a will, because when you die and there are no other people who you named who can have access to that box, somebody who can qualify, typically a close family member, whether it's a spouse or a child, has to go to the court to obtain an order to go down to the bank and get the safety deposit box open. And then the officer at the bank is not necessarily looking for anything more than the will. It's not going to go through your assets, not going to inventory your assets at that time. The court is only concerned about looking for an original will. And that's another important thing. You would have to keep your original will. You can make photocopies. You can have conformed copies executed where you have, in essence, a copy of the original document which you actually signed. Don't sign multiple documents, because that's a recipe for a problem down the road, because multiple documents may be offered to the court as originals, and then you have a real problem. Okay, but if you have a conformed copy where your signature is in the form of an S/ on the signature line, as opposed to your actual signature or mark, that's something that can be admissible as well as a photocopy under certain conditions. But the court is looking for your original will. So keep that will in a place that you would expect your nominated executor or your loved ones to find it, okay? Other than a safe deposit box, because again, that's going to be, you're going to have to get an order to open that box. So keep it among your important papers. Tell somebody where your important papers are so that they're not rifling through your belongings in your house, turning your house upside down looking for an original will. That's not productive time, and that will often lead to conflict, and may very well lead to a fraudulent situation if somebody does have a photocopy of the will. So be careful of that. Know where you're putting your original document. Know and alert people who you would expect to alert. A nominated executor, a nominated backup executor, where that document is so that it's readily accessible. For those of you that don't know, you don't have to necessarily keep the document in your own possession. You can leave it with the attorney who prepared your will. We often get questions in this session as to whether or not you can do this or do any of this without the assistance of an attorney. And again, I'm not here to give you legal advice, but I'm here to tell you that doing this without an attorney, unless you have or are educated in these matters, is a recipe for a problem. Don't do that. Particularly the drafting of some of these documents, because poor draftsmanship or cookie cutter type instruments can lead to problems because they're not addressing all the issues that you had expected these documents to address when you sat down with this sort of do-it-yourself kit. You should really use an estate planner. It's money, it's an investment well worth the time, both at the time you're doing it and down the road, to avoid any litigation that could arise. So
Hi,
be
Joe.
mindful.
That little segment was right on topic for some questions that had come in
Great.
from a participant last night in anticipation of your talk. So
Sure.
This participant's first question is, first, what is the difference between a living trust and a revocable trust? I don't understand. I don't want anything to go to probate. Are they the same thing? or are they different things?
Well, as I mentioned, they're really not, they're not different. The distinction you want to make between trusts is whether one is revocable or irrevocable. Now, revocable trusts can be changed, and there's a blueprint now. For many years, when I first started in the surrogates court in the 90s, there was no blueprint in the Estates, Powers, and Trust Law to tell you how you could change a trust. In other words, how you can revoke or amend what was a revocable trust. And there are now provisions that are close to 15, 20 years old that are in the EPTL, which talk about you have to follow certain directions in terms of execution in order to first execute what's a revocable trust and ultimately to amend or revoke and replace a revocable trust. So that's the difference, okay? The difference is a trust that you want to make revocable, you can amend or an irrevocable trust, you'd probably have to go to a court to seek to do that. And that's not always successful. The permanency of the irrevocable trust goes to the permanency of the estate planning that you do. And there could be adverse ramifications, particularly tax-wise, seek to revoke an irrevocable trust. It's possible, and you would need to round up the consents of everybody that's involved, the person who created the document. If that person dies, now you need the trustees, you need all the beneficiaries, whether they're current beneficiaries, whether they're contingent or future beneficiaries, and it becomes a really unwieldy process. So you have to know, and you also, it's important, as I mentioned earlier, that you make sure that the assets that you want in the trust are listed in the schedule that accompanies the trust, because any asset that's not listed on that schedule is kind of a free agent in terms of assets, and if left in your name alone, you wind up back in the surrogates court anyway, despite all of the planning efforts that you made. So, Sarah, I hope that addresses that issue. Is there any follow-up questions?
There's a little part two to that question that I'm just going to quickly answer. So the living trust and the revocable trust, they're the same thing, different vocabulary for the exact same thing. So the question asker also asked if they could just get a trust online, do it yourself, and then take it to a notary and have it signed. The answer is we wouldn't, as Joe said, recommend that, because a lot of mistakes happen there, especially because this question asker has a co-op. And to transfer a co-op into a trust, whether it's irrevocable or revocable, you're going to need to go to an attorney, because transferring a co-op requires board approval and a full closing, and the attorney for that co-op is going to have to review and approve that trust. So if the participant who asks these questions needs assistance finding someone who can help them, please send us an email through our Ask Us button to avoid ending up in court.
Sarah, you really hit it on the head. Co-ops become a real issue, because co-ops you don't own the apartment when you own a co-op. You walk around and say, well, I own this co-op. You actually own the shares in the corporation that owns the property. So that's the difference between a co-op and a condo. A condo, you actually own the apartment that you're living in. And the ways in which to put that into a trust are much more simple than dealing with co-op boards and so forth. So you got to be mindful of that. So hopefully we addressed some of those questions, Sarah. If I could circle back, to sort of the ramifications of getting into the surrogates court, okay? As I said, in the event that you didn't plan to the extent that there are still assets in your name at the time of your death. You didn't totally eradicate those assets, or you didn't totally transfer those assets into a form whereby the asset was going to pass to somebody as a beneficiary or by operation of law under a trust or under some type of qualified plan or so forth. That's not fatal, okay? As I said, a lot of the matters that go into the surrogates court are usually done on agreement of again, you of course, you've made your will, you're no longer alive at this point. So it's now the executor, the nominated executor has to bear the brunt of coming in and offering the will for probate. And here it's not, you just don't walk in the door, you drop the will in one of the clerk's offices and you leave. There's a little bit involved. You got to pay a filing fee, the smallest of which is $45, the largest of which is for if you have assets that are in your name which exceed $500,000, you would pay $1,250 for filing a probate petition with the original will, to have the will admitted to probate, and therefore the executor, once the will is admitted to probate by the court, will then carry out the instructions in the will in terms of distributing whatever assets still remain in your name. Again, it sounds complicated, but when everybody agrees, it's not that complicated. You have to round up family members, okay? This is where most of the angst is, okay? If you are used to keeping secrets, okay? Let's say you and your spouse have assets and you don't want one child to know of the assets as opposed to the other child. And, I'm a parent of two boys, and I try not to play favorites, but they're 5 years apart, so they have different needs and so forth. It's only natural that you know your children and you know what their capabilities are. You know what they're capable of in terms of their knowledge of your assets. And this is, a conversation I just had the other day with my parents who are in their mid-80s. They've done all their planning. Okay, they have wills. They have what we call in the guardianship part advanced directives, powers of attorney. That's for another day. Hopefully I'll get a chance to discuss that with you as well. But it's a matter of knowing your family members, knowing your spouse, knowing your children. And you have to also be familiar with other family members who may be outside of that close inner circle, because New York's statutory scheme defines who your beneficiaries will be if you don't make a will. And not surprisingly, the statutory scheme New York adopts goes, the closest inner circle are the people who would get your assets first, a spouse and children, or any child of a predeceased child, your grandchildren, if their parent is deceased. And of course, these are the parents and the people that are related to you by blood, not in-laws, okay? So you have to be mindful of those people, and you have to know the dynamics, okay? And if you have difficult dynamics, then you still want to make a will because you feel that that's the best way to dispose of your estate, you have to talk to the attorney who's helping you with the will, who's drafting the will for you, and go through these nuances. This is not the time to keep secrets, because the attorney needs to know who's going to conceivably be a problem because of the way you framed your distribution scheme in your will, especially if it's not even, okay? Now, again, I'm not here to give you legal advice, but the best part of valor is to treat everybody equally. You may have a child who was the primary caretaker, who took the responsibility. This is usually one of the older children whom took you in, lived with that person's family, and that person did all your shopping and your doctor's appointments and travel arrangements and shepherded you wherever you needed to go or wherever you needed to be. And now that person is looking in a will which says, the three of us are treated equally, a third, a third, and a third. And human nature takes over. Okay, I'm not going to lie to you. These are the stories that I used to hear in my office. And the key is, at that point, is to explain to the attorney while you're alive and while you're making this type of arrangement, why you want to treat them equally, why you want to perhaps, in that type of situation where one of three stepped up, maybe you want to give that person half and the other two 25% each. It could be that their stations in life are much different in terms of their own financial acumen. One may very well be more well off than the others. And it's something that, you don't want to necessarily treat them differently, but it may be something where the tax ramifications from how you dispose of your assets cause a disparity that is unintended. So you have to be wary of that. Sarah?
So we just had a question come in that says, should I create a will or a trust? How do I know what's best for me?
Well, I can't answer that. Sarah can't answer that. Bruce can't answer that. you have to sit down with somebody, and you have to, and a professional who is well versed in these issues, is well versed in the different vehicles that we're talking about, and you've got to tell them what your assets are, what your assets could conceivably be based on investments and so forth, based on what your plan is, and a professional will help you plan that out. Okay, so that's not something it's a 2-minute conversation. That's a matter of you sort of getting your ducks in a row, going to a professional, describing to the professional what your current financial situation is, what your desires and thoughts are in terms of how you want those assets ultimately disposed of, and having the professional give you the advice in setting up the vehicles that are going to not only give you the best bang for your dollar while you're still alive, but also avoid any adverse tax ramifications, not only for you, but for your ultimate beneficiaries. And that's not an easy conversation. It's not a short conversation.
And one of the best things you can do to start that conversation is to create a folder of all of the most recent account statements in your picture. If you have any real estate, write down what it is. Then think about where you would want those assets to go should something happen to you. Maybe it's a spouse, children, family, charity. Make a list. And then once you have your notes together, to reach out to a professional in the community and sit down and to have a conversation.
Very good directive, Sarah. Reluctant to say advice at this point, but that's some good direction. I see a couple of questions in the chat that I want to take a time out here and address, because one is very basic and one's a little bit more involved. What is the difference between a will and a trust? How to tell which one is best for you? Okay, well, I spent a lot of the first half hour here talking about some of the nuances. And in the long run, there's not much difference. It's ultimately how those instruments are carried out that is the difference. For those of you that don't know, when you make a will, you can actually create a trust within the will. In fact, it's fairly common to do that. Those are called testamentary trusts. They're embedded within the context of the will itself. Now, if you want to create a trust during your lifetime, those are called lifetime trusts or living trust, or inter vivos trusts among the living. It's a Latin phrase that we use. We call them IVTs. And the difference really is a short-term, long-term analysis. Okay, the trust is really put into place more for the longer term and more for probably in a lot of cases, multi-generational levels of beneficiaries, where you're not just looking to shield your assets and perhaps have income or principal available for one set of your ancestors below you, but perhaps for multi-generations of that. And a trust is a better vehicle for long-term planning in that respect, because you can do that within the trust. The trustees that you choose will manage that. They will use discretion in terms of making distributions of principal assets or income, however you frame it in the trust. A will is much more cut and dry, because the will is not meant to be a long-term vehicle. It's meant to give direction at the moment of your death as to how you want your assets to be disposed of, and those assets may be disposed of into additional vehicles. It may go outright to somebody. Assets may be put into further trust. So if that's the one characteristic, again, you have control over what you want to say in these instruments. And if I could just differentiate based on the question, the key difference is in terms of whether one is sort of a long-term operational factor, which is a trust, as opposed to an immediate or a shorter-term operational or administrative factor, which is the will. They're all your thoughts. They're all your directives. But one is for a much longer term, or envisioned to be a much longer term than the other. Another question, interesting. I have no children, have a life partner and siblings. If I leave my assets to partner and one sibling, so this presumes that you're going to make a will, can my other siblings contest? And the answer is yes, because your other siblings would be parties interested in the estate. Your life partner, again, the the legislature has not quite caught up to the common law in New York in terms of who is a spouse and who is not a spouse for the purposes of the cast of characters who are interested in one's estate. Because if you do have a spouse and children, you don't necessarily have to worry about siblings. But if you have a life partner and siblings, then the siblings are clearly involved. And if you treat one disparately from the others, you can expect that the siblings who have a right to be heard with respect to the validity of such an instrument that's offered to the court, they may very well contest. But they can't just contest on the basis that they're not happy. There are actually 4 primary grounds for contesting a will. Just briefly, I'll alert you to what they are without going into the legal nuances. The first is that the will wasn't executed properly. In New York, you have to execute a will with certain formalities, including 2 attesting witnesses who are acting at the behest of the testator, not of your spouse, or not of a friend, or somebody who's either you or somebody you authorize as your agent to ask those witnesses to act on your behalf. They have to act within a certain time period. I believe it's 30 days. Of course, Sarah can back me up on this. That's, if you don't have everybody do this in one sitting, that's a recipe for a problem. You want to do your will with everybody there that you need. You want the witnesses there. Sometimes that's not possible. But COVID, if anything, has given, trust and estates attorneys hope that, now you can do a lot of this remotely, at least for the time being. And it could very well be that a lot of the procedures that have been adopted using the technology that we're using right now, for instance, in terms of will executions, may very well survive the pandemic and become a part of everyday practice.
And as a private practice trust and estates attorney, we've seen a lot of clients doing their documents remotely. There are a number of provisions in New York State which you have to get through in order to do a remote signing. You have to be able to video conference. You have to be able to show photo ID for everyone who's signing. You have to affirm that you're physically present in New York State. We do the signing with the witnesses on Zoom like you are today. And then right after the signing, you have to scan and email or fax the documents you just signed to the attorney, so the attorney and the witnesses can sign the documents. And then you have to send the originals back to the attorney's office, and the attorney and the witnesses have to duplicate the witnessing and notarization within 30 days. So while a remote signing is absolutely possible, most practitioners have done them pursuant to Governor Cuomo's executive order for the emergency disaster relief due to COVID-19. It is a bit of a dance where the person signing does have to have the technology on their end to be able to scan or fax the documents back. I've even had someone photograph them back because they didn't have a scanner, because they're still digitally transmitting them back, but it's for every page that you're signing. So it's not just the signature pages. So that makes it a little bit more complicated. But, there are provisions in the law, and it's great how the state and the courts have been able to pivot to make services more accessible to everyone who's trying to stay home and stay safe.
And Sarah, that's a great explanation of what the current state of the law is now since COVID. And I have had discussions with people based on my experience in the surrogates court that this may very well be a permanent fixture with respect to how wills get executed because of the convenience. For the longest time, I was just sharing this with my law school class last night. You want to always honor the testator's wishes. And if the testator has the 2 witnesses that are on either end of the country, one in New York and one in California, this was a problem. You could say, well, we got 30 days. We can do this twice. We can have 2 ceremonies, but it's hard to duplicate the components of the ceremony for each witness to satisfy. So that was always a problem. This may very well help solve that issue and become a permanent fixture. And I would welcome that. I think that's safer. And again, Sarah, as Sarah was explaining, it has to assume that the participants have the technology to make this happen. Mm-hmm. So some of the other issues, just quickly, one has to have the appropriate testamentary capacity to make the will, which means that you have to understand at the time that you make the will, you have to understand the nature of your assets, the nature of the people who would expect to be your beneficiaries, and so forth. And that usually becomes a contest when somebody's been hospitalized or they make a bedside will or something like that. So things to be aware of. Also, when somebody has been unduly influenced into making a will or actually defrauded into making a will, and those are more legally technical issues that I don't want to get into right now because that's an hour-long discussion in and of itself. But those are the typically, again, due execution or lack of due execution, lack of testamentary capacity, undue influence or fraud. Those are the typical reasons that one would be able to contest a will. Not just because they're not happy with the way the will turned out, or that there was an earlier will in which they were getting much more of a gift than they are under the will, which is later in time, which is being offered to the court.
Joe, we have a very interesting question that just came in.
Sure.
And our participant says, can you write out your own will, or do you have to have one done by a lawyer? Is writing out your own will legally binding?
Good question. Okay. And the answer is it's possible. It's conceivable that writing out your own will can be a valid will. It is not recommended that you do that because, as I suggested, New York has a statute. It has a blueprint, formalities, okay? So as you're writing out the will, you have to be sure that the witnesses are there to witness and do what they need to ultimately report to a court that they saw and observed, okay? These handwritten wills are typically more acceptable in the time of conflict, in the time of Army service in the Army. They're in time of armed conflict, where the formalities cannot usually be met because of the various soldier or seaman situation, and they have to be quick about the way they do a will because of the pressure that they're under while serving in the armed forces, usually in a combat type situation. So it is conceivable. Okay, I don't recommend it because if you're doing this yourself, you may overlook one of the important criteria that the will execution statute in New York under the Estates, Powers, and Trust Law provides. So I do not recommend it. Okay, it is conceivable though. Okay, so I know we're getting towards the end, and we're happy to take some questions at the end, but again, my goal, or one of my goals, was to dispel you of the fact that going to the surrogates court is an absolute horror show, and that's not the case. As I said, many times families have talked about these issues. They've talked about your estate plan ahead of time. They're on board, and those are the matters that usually go through swiftly. And I'd say that 75 to 80% of the matters in the Westchester surrogates court at the time I was there were uncontested. In fact, they were probably, from the time that the application was walked into the court and the filing fee was paid for the basic service of having the will offered for probate, to the time that the surrogate signed a decree admitting the will to probate and saying that the will was valid and that the executor can now do what the executor has been designated to do under the instrument, that time frame was anywhere from a month to 2 months. It's a little different now because of COVID and the volume that has backed up in the weeks where the surrogates was not allowed to do that. Here in Westchester, you're probably looking at 2 to 3 months now, which is still not bad. Of course, if there's need for immediacy, let's say your estate is heavily in the market, you have a lot of securities, and we're in a volatile market, you can have your executor apply to the court for what are called preliminary letters testamentary, to sort of an immediate authority to do what you need to do with the assets, particularly the securities, to make sure that there's not a precipitous loss because of a volatile market or something along those lines. So a preliminary or temporary fiduciary can be put in place to alleviate any of those issues while the probate application is actually before the court. So it's only when you have bad dynamics in your family, okay, and you can look right into somebody's heart to know that no matter what you do, they're going to be inclined to contest your ultimate desires and wishes as you've expressed them. And somebody did mention in the question thread, Sarah, and I thought this was interesting. Does a trust avoid a contest? And that's not necessarily true, because somebody can always contest the trust on the basis of the fact that you didn't have the requisite capacity to make the trust at the time that you made the trust. So a trust is not immune to any attack. It's immune, in terms of, as I said, there are now, there's a blueprint in place in New York since the mid-90s, which shows you how you have to create a trust that's created. I believe it's 1997 and beyond. That blueprint takes effect. So any trust created over the last 25 or so years have to be done within the requisites that are specified in the Estates, Powers, and Trust Law. And those could very well be grounds for vacating the trust just as easily as it would be grounds for vacating a will. Sarah?
Agreed. Just that the trust doesn't have the same notice requirements as does a will when it has to be probated with the court, where there's a class of people who are your heirs at law or your distributees in legalese, where they have to get notice and they have to consent to that probate. With a trust, the same criteria is not there, but as Joe said, a trust is not contest proof, and you can have a trust contest just like you have a will contest. And if you have a family or personal situation that you may expect something to happen, it's really important that you seek out good counsel from an attorney and that you have a document that's drafted in such a way to accomplish your wishes and make sure that the rest of your estate plan follows that. So it's the best you can do to avoid that situation, but no plan is perfect. We also have a lot of questions that have come in. So in terms of the questions that just came in the chat, besides real estate, what assets should be included in a trust? How do you decide? And what is a Medicaid trust? So on this particular program, we're not talking about Medicaid and Medicaid trusts. We do have other videos on our website that specifically deal with Medicaid and Medicaid planning and those sorts of irrevocable trusts. And if you send us a query through our Ask Us button, we're happy to direct you to the content or to set you up for a free 15-minute consultation for our free consultation program that's happening later this month. But when you're doing a trust-based plan, the idea is that all of the assets would be owned by the trust or by beneficiary designation, so that you don't need to look to the court to probate a will. And we'll answer the Medicaid questions on another program. We have a lot of questions that came in. So Joe, can a grandchild inherit if there's no will?
Yes, a lot has to happen. And again, Sarah, that's looking at the intestate distribution scheme that I alluded to earlier under Estates, Powers, and Trust Law 4-1.1. So here's what has to happen for a grandchild to inherit, okay? Number one, the decedent would have to be survived by a spouse and the grandchild or grandchildren and the grandchild's parent would have had to have predeceased our decedent. So that's one way in which a grandchild accedes to the status of being an intestate distributee and would be entitled to a percentage based on where that person falls. If there's no spouse, but there are live children, and let's say the family unit was 2 spouses and 3 children. One spouse A dies, leaving spouse B and children C, D, and E. Any children of C, D, and E, as long as C, D, and E are alive, would not be able to inherit an intestacy, okay? Because they're blocked by a live parent. If any of the children, C, D, or E, predecease A, then depending on how many of those children predeceased, a pool of grandchildren who conceivably would inherit is created. If, let's say, C dies, and A dies, but C died before A, leaving spouse B and children D and C, and if C had children, let's say C1, C2, and C3, well, C1, C2, and C3 would in essence they would get the share that their parent would have got, C. If C and D predeceased A, E is still alive, and if C and D had children, C and D's children are pooled together, and however many they number together, they would split whatever shares C and D would have gotten by, let's say, C had 3 children and D had 2 children, and E is still alive. So E would get a third. Again, and the spouse would get what the spouse gets, which is the first $50,000 plus 1/2 of whatever's left over, and then E and the 5 grandchildren would split. E would get a third, and the 5 grandchildren would split 2/3 of 50,000 of the first 50,000 off the top going to the spouse, and then the spouse getting 1/2 of whatever's left. So it's a little confusing to talk about that, and it almost becomes a law school exam, but it is conceivable that a grandchild can inherit. But the right situation has to occur, and that usually means not being blocked by a live parent if you're a grandchild. That's the best way I can simplify it.
Okay. So, Joe, another question that came in is, my power of attorney and healthcare proxy are over 20 years old. I'm in my 70s. Nothing has changed in my situation. Should I be redoing these documents?
Well, the power of attorney instrument in New York is in constant flux. The last time I think it was changed was within the last decade. There's a movement afoot now to implement further changes to it. If you are capable of changing that, and again, if nothing has changed, and it's very rare for somebody to say that nothing has changed in their life over 20 years, because the dynamics of families do change. You may have had falling outs and so forth, and if you were fortunate that nothing has changed, God bless you, because that rarely happens. I would certainly think about the power of attorney and modernize that document, because the document now should come with what's called the statutory gifts rider, that if you executed this 20 years ago, you wouldn't have now. And the statutory gifts rider is important. It's actually important for what I'm doing now in the guardianship part, to have those advanced directives in place so that you have somebody via the power of attorney who is capable of taking care of your financial matters, and you have somebody via the healthcare proxy who is capable of taking care of your personal needs matters, so you won't need a guardian. If those advanced directives are done properly, if they're complete, and I'm suggesting to you that a 20-year-old power of attorney is no longer really complete, you need to update that document for the statutory gifts rider and for the changes that are being circulated as we speak. But the healthcare proxy is probably still good and hasn't changed much. You should know that in the event the healthcare proxy is eventually becomes an issue and cannot be found, that it sounds like, given your circumstances, the Family Healthcare Decisions Act is in place and can probably meet those needs without you having to execute a new document. But 20 years is a long time for a will or for these types of advanced directives. You should always try to be as current as possible. Again, I'm going by your representation that nothing has changed in terms of the people you've selected, and if that's the case, just update as I've suggested, and particularly with respect to the power of attorney.
Thanks, Joe. And also with healthcare law, even if your situation hasn't changed, there's now new documents. So 20 years ago, if you were 50 and now you're 70, you might be thinking differently about your healthcare. So if you have a do not resuscitate order, there's a Department of Health form called a non-hospital DNR, which can be completed by your doctor, which the only medical order, not for a lawyer, but a medical order on that form is a do not resuscitate. And there's also, for people who are looking towards end-of-life care or who have very specific medical wishes, can have their doctor complete a MOLST form, which is medical orders for life-sustaining treatment. which has more orders than a non-hospital DNR. It has orders for resuscitation, but also for intubation, which is a breathing tube, antibiotics, whether you want artificial nutrition, hydration. And those are important pieces to your healthcare planning puzzle as you age, especially if you're hoping to age in place at home in the community. And those are good companion documents to have in addition to the healthcare proxy, especially if it's 20 years old, because they would all now be HIPAA compliant, those new Department of Health forms, which have also been created in the past decade. So we have a lot of questions coming in, Joe.
That's good. No, I'm happy to stay on as long as you need me to, Sarah.
Okay.
It's very interesting that you mentioned that, Sarah, because a lot of people may be familiar with the term living will, and those were typically the instrument that was used years ago to give your wishes with respect to do not resuscitate or do not intubate. And now those are being replaced by the more modern documents that Sarah is suggesting. And in the court that I'm in now, the Supreme Court, the guardianship part, we're seeing most forms. In terms for healthcare issues. So that's an evolving process as well. So it may very well be that it would be a good idea for you to the person who asked the question to not only revisit your power of attorney, but also maybe to revisit your healthcare documents as well.
Right, and the healthcare documents that we just mentioned, they're documents that your doctor would do for you, not your attorney. So we can do healthcare proxies, which appoint a decision maker, or a living will, which I think of as like the belt and suspenders to the healthcare proxy, which gives your specific wishes, but those are just legal wishes. They're not medical orders. So to get a medical order document, you have to go see your general care practitioner. And it's important to have that ongoing relationship as well. So I'm gonna jump to another question. So what is the cost for consulting with an attorney for estate planning? And it varies per attorney, but the Senior Law Day Collaborative offers free 15-minute one-on-one consultations to help point you in the right direction regarding your legal issues. And the next free consultation date, Bruce, jump in if I get the date wrong, I believe is October 28th. And that will be able to help pinpoint issues for you. So if you're interested.
Actually, Sarah, it's October 29th.
Thank you, Bruce.
And you
so
go
October.
From Thursday from 10 to 12, but you're right, on the 28th at 3 p.m., you have to go sign up for a time.
So if you're interested in a free 15-minute one-on-one consultation with an attorney, a certified financial planner, or a geriatric care manager who manages senior health care, you can sign up as of 3 p.m. on our website, seniorlawday.info, and the link will be live. The cost for the free consultation is everyone's favorite number, which is 0, and we'll point you in the right direction to have your questions answered. Okay, so Joe, interesting law school question here. What is the purpose of having 2 witnesses sign the will? Can they be one of the beneficiaries of the will, or do they have to be disconnected from inheriting? Also, what if the witness dies before the person writing the will? Do you have to do your will again? What if the witness can't be found if you die? That's a very good question.
All good questions, and then it's going to take a couple minutes for this to unfold, so bear with me. The first question, or the first component of this, is the statute provides that you have to have 2 disinterested witnesses, okay? Which means not that they don't care, not that type of disinterested monetarily. You're not supposed to use witnesses who have a financial stake in your estate. Now, is using a witness who has a financial stake in your estate fatal? Not necessarily, but that witness is running the risk of having whatever benefit they're getting under your estate disqualified. So use somebody who has no monetary interest in your estate. The 2 disinterested witnesses is because that's what the legislature deemed appropriate. The legislature that framed these statutes framed this on procedures that existed long before the statutes existed, and it's usually because you want to have at least one person who can corroborate what the other did, and vice versa. And that's probably the easiest or simplest explanation I can give you. Now, as far as your other questions, which get a little bit more in depth in terms of the witness's role. What if a witness dies during, before you die, and therefore after you die and your will's being admitted to probate? What happens? This was a problem many years ago because you typically needed to get testimony subsequent to death from both the attesting witnesses, and that usually came in the form of a form under one of the statutes under the Surrogate Court Procedure Act. And that form is what the witnesses fill out after you die, and they basically go back, and the form is sort of, it's pre-prepared for you in terms of what to say, but you're going through what you witnessed as a witness. Now, that's avoided by and large today. Okay, when I was in the surrogates court back in the mid-90s, I'd say the wills were probably about 60%, 40%, where 40% of which the attesting witnesses did not execute the document I'm going to mention now, which is called a self-proving affidavit. It's an affidavit that the two attesting witnesses signed and affirmed to at the time of the will execution ceremony. So as the will is being executed, the witnesses will sign, and this will be notarized and kept with the will, this self-proving affidavit. And the affidavit basically is each witness affirming what they witnessed, and the witness, again, the language is set out for the witnesses in terms of what the statute provides that they attest to, that they saw, so that that document is there with the will for posterity. So if 30 years later you haven't changed your will, and you now need to try to find these witnesses, you don't have to, because you have the self-proving affidavit, and that avoids having to look for witnesses or having a situation, as was suggested in the question, where the witness predeceases the decedent. And you would be in a position, had you not done the self-proving affidavit, where the court might not admit the will to probate because you only have perhaps one of the two attesting witnesses still alive. So, good question. And again, a lot has to unfold for that to happen.
Okay, we have a lot more questions for you to answer, if you don't mind staying with us.
Sure.
For just a bit longer. So, okay. They're coming in the chat and in the Q&A, so.
Yeah. Sarah, just quickly, somebody had mentioned in the chat, if you have a 17A guardianship, that's the Surrogate Court Procedure Act, Article 17A, for mentally or intellectually disabled people. You can get a guardian in the surrogates court, as opposed to the guardianships that I do here in the Supreme Court, which usually involve elder law issues, Alzheimer's or dementia or other aging issues. But a 17A guardianship for somebody who is an adult child who is disabled, do you also need a healthcare proxy? Well, if you're asking if that person, the disabled person, can execute a healthcare proxy, the answer is probably going to be not. So the fact that you have a guardianship in place has some value to it. A 17A guardianship is limited to the extent that it doesn't have the same breadth in terms of some decision making that a healthcare proxy allows, but it'll do probably for the lifetime of this person. And I'd rather not use this forum to go into the nuances of the different guardianships that are at your disposal for somebody who has these types of issues. That's a little bit beyond now, but in terms of a healthcare proxy, the way the question is framed, the incapacitated person or the person for whom the guardian is appointed is not going to be able to execute a healthcare proxy at that point. So the guardianship will do to the extent that the transactions at 17A guardianship is permitted to do by statute will occur.
Thank you, Joe. So we have two questions regarding the healthcare proxy forms.
Sure.
So the first, where you could find a basic form would be on the New York State Department of Health's website. And there should be basic healthcare proxy forms that can be downloaded. Also from that form bank, there's the non-hospital DNR, and there's a copy of what the MOLST, Medical Orders for Life-Sustaining Treatment form, what that looks like. But the original of the MOLST form is a specific color pink. It's pulsar pink, and that form is supplied by your medical doctor's office. But the healthcare proxy just appoints the individual or individuals that you would like to make healthcare decisions for you. So back to a question for Joe. What do you have to do to end an estate settlement process?
Well, again, I'm going to assume that the person who's asking the question is not talking about a contest of any sort when they use the word settlement. Because as a person who spent their career in the court system, when you hear settlement, it usually means that you had a contest. Let's assume that that's not the case. So I'm going to read the question as the final step to be done to end estate settlement process. You offer the will for probate by filing a probate petition and the original will. You serve process, or you get what are called waivers and consents from the parties who by statute have a right to be heard, who are, again, usually family members, and usually people who would take the estate if there wasn't a will. So those are your intestate distributees. In the event that there is no contest, the court still has, by statute, it has to look at the validity of the will, which means it will look at the will itself to make sure that it looks pristine. There aren't a lot of interlineations on it or anything under the signature line, which by law is not to be regarded in terms of instructions. And it will look at the witness affidavits. If there's a self-proving affidavit, as I was suggesting 5 or 10 minutes ago, that's great. If there are the form affidavits that the witnesses who are still around are able to complete, the court will look at that and make an assessment. And if the court is satisfied that the will appears to be executed as it should have been, that the witnesses indicate that to the best of their knowledge, the decedent had the requisite capacity to make the will at that time. And if there doesn't appear to have been any undue influence or fraud in terms of the actual provisions of the will, the court will sign a decree indicating that the will is admitted to probate. It will issue what are called letters to the executor or executors, so that the executors have the authority now to go and do what the will, what the decedent wanted to be done under the will in terms of making gifts and other directives. So that's ultimately the probate decree is the final say that the surrogate's court has in the probate process, whether a matter is contested or not. That's the goal, to get the surrogate to sign the probate decree.
So we have a question about condos, which of course are a bit different than co-ops, which you addressed earlier. So the question asker is in their 70s, and they're looking for the best way to put their condo in the name of a relative to protect the asset as a trust, the single owner or joint ownership. So I guess the question asker is saying, what's the best way to protect her condominium?
Well, as I suggested earlier, a condominium is in essence real property. So there are trusts for which you can use to hold the asset, and that's probably the best way to shield that type of asset. And you don't have the scrutiny that Sarah had suggested earlier that you have when you have co-op shares and you don't have a condo, because you're not going through the co-op board for approval, and that could be like pulling teeth. It's really difficult to get co-op boards to agree on anything, let alone to the shielding of their precious co-op in a trust. But in order to protect the asset, again, and giving you a very basic answer here, because I would have to know more about your financial situation and the ramifications of just isolating this one asset into a trust. The primary way to do this would be to do some type of real estate trust for the condo.
Thank you, Joe. So question is, having had years of experience in the court system and also being a teacher, how would you advise someone like me to start planning? What should I think about? What should I do? And how do I avoid making mistakes?
You're asking a lot,
that's
okay?
a broad question.
That's very broad, yeah. And thank you, for your faith in me. again, I'm as a member of the court, I'm not permitted to give legal advice, but the first step you would do, and Sarah would probably back me up on this as somebody who isn't a planner and who does this type of work. You have to take stock of your assets, and you have to take stock of your family, okay? And if you can do that on the same piece of paper, that's great. If not, use 2 columns. And these are the do's and don'ts and the issues that an attorney is immediately going to want to know about family dynamics, about the nature of your assets, and ultimately, the third component to this discussion would be, what do you envision in terms of the wherewithal that you have during your life, and ultimately how you want to treat the people who are your loved ones and those that you want to provide for when you're gone. To get into specifics, again, we would have to know the specifics of your family dynamic, your assets, and what your hopes and desires were in terms of your needs while you're alive, as well as what you would like to see your assets do for people once you're gone. And those are the 3 that, if you can think of the old circus where you have the 3-ring circus in the front, and I'm not suggesting that, in any pejorative way, but that's the type of balancing you have to do. You've got to sort of keep an eye on what's going on in all 3 rings at the same time. And if you've ever been to a circus, it's very difficult to do sometimes, particularly when you've got, kids who, were crying for popcorn or soda or anything like that. So if you can juggle that somehow and keep your 2 eyes on all 3 rings at the same time and present that information in a coherent fashion to an attorney, that's your best start.
Yeah, I agree. And I think that doing the planning is an important piece of self-care, especially in this time when so much is different. So when you have a few minutes to yourself, write down, make a list of your accounts, make a list of who you wish to benefit, and then think about what your goals are. If it's to fund your health care through retirement, long-term care, if you are lucky enough to be at the point where you're looking to do tax planning and are looking to be generous to charity or members of your family, and then to reach out to a professional who can help you articulate those goals on paper. And there are many fantastic attorneys and certified financial planners in Westchester County who can help you do that. And a question came in, so they want to know if we're all from the same law firm. So while I'm a private practice trust and estates and elder law attorney, today in this capacity, I'm here as a co-chair for the Senior Law Day Collaborative, trying to put out good and free information to the Westchester County community, so individuals have a starting point to help them with their own plans and have their own questions answered. Joe Accetta is a long-term member of the Westchester County court system, and Bruce is a fantastic marketer who works with both private practice entity as well as in the nonprofit world, and we're very lucky to have him. Our other co-chairs are an attorney with Legal Services of Hudson Valley, who provide free legal services to individuals with limited means, as well as the Director of Public Engagement for the library system that has so many fantastic programs for people in Westchester County. And if you have questions about library programs, access to services for people with vision impairments, reentry, we have great resources to connect you with. So,
Sarah, before we wrap up, I just want to take a minute. I've just shared a quick thank you to all of our sponsors who made, we had a lot to do to continue these programs virtually once COVID hit. And I just wanted to take a moment to thank our sponsors who made it possible. So,
all of whom, or many of whom, are, as is Sarah and Sarah's firm, Keenan. They're valued members of the legal community here in Westchester, and I've had the honor for many of them to come before me in the 2 courts that I've worked in here in Westchester over the past 25 years. So they will serve you well. A lot of the sponsors that you saw on this program, they will serve you well, and hopefully if you do go for consultations, be forthright with the attorney so that they can give you the best advice and direction possible. Okay.
Any last questions for Joe? And if you think of a question after we finish today, send it to us through our Ask Us button on seniorlawday.info, and we will get that question answered for you. And Joe will be back early next year for another fantastic program on powers of attorney and guardianships. So we're going to be able to continue to ask him questions and use his knowledge base. So Joe, thank you so much for
that, Sarah. Thank you. It's been a pleasure to be here with you this morning. So
we had another question come in to send questions to what email. So on our website, www.seniorlawday.info, there's an Ask Us button, and you can enter your question there and then click accept, and it will come to us and we'll get back to you with all questions. So thanks so much for joining us.